What's up, everybody? Supreme Decisions here, and today I want to talk to you about a warrantless search of a vehicle. Now, we know from Arizona v. Grant from 2009, which was a U.S. Supreme Court case, that was holding that the Fourth Amendment of the United States Constitution requires law enforcement to demonstrate an actual and continuing threat to their safety that's posed by the person that they are arresting. Now, when you're talking about this, we're going into the realm of exigent circumstances. So they would have to need to preserve evidence that's related to the crime of arrest. Because remember, you can only be arrested upon probable cause, and probable cause only comes from a crime. Right? Now, when you're talking about this, you're talking about the exigent circumstances of the arrestee being able to tamper with or destroy evidence in order to justify a warrantless vehicle search. And what they also do is try to use a search that's incident to arrest. It's conducted after the vehicle's occupants have been lawfully arrested and secured. Now, understanding this aspect of it, because I gave you the case where it spoke about police officers don't know what probable cause is, so they need a warrant from a judge or your consent. Now, I'm going to go into how they're asking questions where if you just simply say no, that's going to be used as an implied right. But if you actually say, because even my children, their first words were, I do not consent. Because you can't misconstrue, I do not consent. But understanding this, police must obtain a warrant prior to entering one's property absent consent or exigent circumstances. Now, I'm going to say part of this for the masterclass because I'm going to get into a couple of things that deal with what you're going to ask if it gets to a point of being in or preparing for trial. Now, first question, what were the exigent circumstances that allowed you, the officer, to enter the property? Which would either be opening a car door, going into someone's home, or behind a residence. One of those, the next question, or you can actually ask this in conjunction with, was there a chase? Because that would fall under exigent circumstances. Now, if you're on the side of the road, the biggest incident or the biggest question that could be asked is, what evidence could have been destroyed? Because generally, this is one of the easiest questions when you're on the side of the road for a traffic stop, because if you're not giving consent, they have to come up with a means of getting that warrant or figuring out exactly what it is that they were supposed to do, which is a crime that would allow them to go into the vehicle absent your consent. Because once you are more than arm's reach from the vehicle and the car is secured, which is pretty much the doors are closed, they're only allowed the plain view doctrine, because whatever they can see looking through the windows, they are not allowed to open the doors and go into it. If they do that, it becomes an illegal search, and everything that is then found after that is part of the fruit of the poisonous tree. But there's a way to establish that. And again, that's something I go into in this masterclass. So always understand that. You have to understand the context within each aspect of each case and how these precedents apply to your particular case and how you can enforce them. So let's keep going. Let's keep growing.